Welcome to the legal podcast containing legal questions and answers in layman's language. Today's topic, construction site accidents. I'm so delighted to welcome as our expert guest here today, Nick Gjelaj, and Nick is from the firm of the Gjelaj Law Firm, and Nick is a highly prominent trial lawyer and is one of the leaders in our many legal organizations throughout the city. So it is a pleasure to welcome you, and thanks so much.
Well, the pleasure's all mine, John. Thank you so much for having me and those kind words.
I mean that very much. Now, let's begin by asking, why are construction site accidents so significant in relationship to the personal injury field?
That's a multifaceted question. I mean, every personal injury case involves a human being, but on these construction accident cases, we're talking about people who are injured while they're working to presumably provide for their families. Construction sites are very dangerous. The biggest type of accidents are falling objects onto the workers or workers that fall, whether it's from a scaffold, a ladder, a platform. So when these people are getting injured, they're falling a great distance. They're breaking bones. They're injuring their backs. They're injuring their necks. And for the most part, and I've said this to juries, their injuries prevent them from doing their physical labor. The defense always talks about them being potentially able to do another job. But these are construction workers. These are not people who had the option when they graduated from high school to either go to Harvard or go into the union, for example. They took what God gave them, in this case, their might, and they ran with it. They don't have plan Bs. They don't have plan Cs. So you're dealing with the physical toll. You're dealing with people, for the most part, who are working people. And believe it or not, you always say, I want to retire or I wish I had off. These people are losing their minds, not being able to do what they love. So you get that human factor, you get that physical factor, you have economic loss there. You have people who are earners, who are earning money that they can't earn anymore. So when you combine all of that, that's why they're so significant.
I mentioned before about you being a very prominent trial lawyer, and that's so significant. And I think it would be helpful to our clients that are watching and listening. It's a couple of examples maybe of some cases that you've had that may be reflective of the issues that you speak about in terms of construction sites.
Okay, one that comes to mind was, about 10 years ago. He was a union tin knocker, a sheet metal worker, Local 28, and he was working at the Staten Island Ferry Annex. And he was on an A-frame ladder, and the ladder collapsed. And he was falling head first. In order to prevent himself from taking a header, as we say, he extended both arms out to break his fall. Well, he broke the fall, but he broke every single bone in both arms. He tore every muscle, tendons that I hadn't even known of at the time that I know of now. And because of that, he couldn't work anymore as a tin knocker or as a construction worker. This was a gentleman who dropped out of school, got his GED. He grew up in Staten Island. He was an Italian fellow, and he went into the union. And he had done this, I think, at that point for about 10, 11, 12 years. He thought he was going to ride this out until his retirement. His life got turned upside down. Besides the fact that he had 8 surgeries, he was earning about $120,000, $130,000 a year as a union worker. But that's not the whole package. Being that he was in a union, he had an annuity, he had a pension, he had vacation time. He had all these benefits that are associated that he lost. So we went to trial on the case. He took the stand. And the difficult part is, it goes back to what I said a little bit earlier. Theoretically, could he do something? Well, yeah, I mean, just about anybody can do something. But practically, and that's what we were able to prove at trial. They brought in a vocational rehabilitation specialist who said he could be a real estate agent. Case was venued in Manhattan. One of our jurors was a real estate agent and had heard our client testify. Now, I'm not disparaging my client, but again, he's a construction worker, not some erudite person that can bring Manhattanites to apartments and sell them. And we basically looked at him right in the eye, that juror, and said, really? You think that he can do that? And the guy chuckled. So we had to disprove the notion to a jury that this guy could do something. Again, theoretically, he could do anything. But what's practical? What's out there? Does he need retraining? Also, this gentleman needed future medical care. We hired a life care planner, basically like a jack of all trades. Reviewed all his medical records, gave him a lengthy exam, generated a huge report, but most importantly, a spreadsheet which said what the future holds for him medically and how much that costs. Now, this was a medical doctor. Remember something, and I don't need to preach to you about this. What cost $1 does not cost the same dollar 10 years from now. Just like it didn't cost $1 10 years ago. It's because of inflation. So we retained an economist not only to project his lost earnings and benefits, but to discuss the life care plan, because my client was 30 years old. His life expectancy for a man is 79 and change. So he had a huge amount, almost 50 years of life expectancy. And when inflation took over, those amounts went like this. And the jury gave every single penny that the economist testified to, both as to wages and as to medicals. The total verdict was about $15 million. It was reduced a bit on appeal. You know, everybody hears about these verdicts that come in, you read them in the paper. You know, recently, I'm not sure if you saw it, there was a transit case where the person lost toes and was partially paralyzed. I think they awarded him like $100 million. I hate to break it to that attorney. He's not going to keep that much because cases get appealed, in that case, to the first department. And we have parameters of where these verdicts should be for pain and suffering.
Now, let me ask you, I know each case is different, but generally speaking, who are the defendants that you deal with in construction site cases?
Very good question. So the labor law, which is the fancy term for the law that governs construction accidents. You know, when you say labor law, most people think of like union labor sites and stuff. This is a different part of the labor law. The labor law says that the owner and the general contractor have a non-delegable duty to provide a safe workplace. Now, that's very general. Okay, it's more complicated than that. But when you have a labor law case, you sue the owner and you sue the general contractor as long as your client was not employed by the general contractor, because in New York we have something called the workers' comp bar. You are not allowed to sue your employer in New York. That being said, the employer works his way into the case because your main defendants, the owner and the general contractor, can bring them in as a third party. Even though you don't have a direct claim over them, they're still in the case. So we sue the owner and the general contractor. On some occasions, the site safety company, but that's only if they have the authority to stop the work. If they do.
What is meant by the term third-party claim?
Okay, so when you get hurt at work, regardless of what you're doing, you have different remedies that you have. One is guaranteed. That's workers' comp. If you're hurt at work, you qualify for workers' comp, regardless of faults or anything like that. You get your medical bills paid, and you get your wages up to a certain amount. Third party is a lawsuit that would be filed. Not everybody that gets injured can pursue a lawsuit. You know, for example, if it's a 240 case like we've been talking about, you need a fall from a height, or you need an object that falls on you. If it's a 241-6 case, that's a different area of the labor law, you need a violation of the industrial code, but that's not enough. You need a violation of what's called a specific regulation. And what is specific? What the appellate division tells you is specific.
Okay. Let me ask about an individual is in a shanty and he's walking over to the job site and there's a truck there that is operated by some third party and a piece of pipe falls off and breaks the client's ankle. Is that a case?
It is a case. And in that case, being that it's not the employer's fault, okay, there's not going to be a workers' comp bar for any defendant. We would sue the owner of the property. We would sue the general contractor because, as I said before, they both have a non-delegable duty. But based on your fact pattern, it sounds to me like the active tortfeasor, the person that's at fault, would be the truck company for allowing this unsecured object to fall onto someone. They would get sued as well. Now, the owner and the general contractor, they're in statutorily. But in these types of cases, it's not always who the plaintiff sues. It's the defendants suing each other for contribution and indemnification. And I think in your fact pattern, it would all get put onto the truck company.
So what happens if that same truck is owned by the company that the worker works for?
The owner and the general contractor can still be sued. The way I was taught this is that the owner and the general contractor basically step into the shoes of the employer. You can't sue the employer, but any, quote, negligence by the employee gets imputed up the chain to the general contractor and to the owner. So it's a difficult statute for some people to wrap their heads around because it's a vicarious liability statute. And the reason that's the case is because, and we're one of the few states in the whole country that have the labor law. But the reason is when all the buildings went up in Manhattan, you had people dying constantly. And the legislature took action in order to ensure that workers are protected from, especially from working at heights.
Not to go too much back in history, but why were there so many construction site accidents during that early years?
Because there were no laws in place. There were no mandates that people had to be provided with lifelines, with the harnesses that they would wear. Right now, OSHA says that you can't just tie off anywhere. That anchorage point has to withstand the average body weight of 4 people. It's got to be tested by a designated person. None of those laws were in effect back then. And I don't know if it's true. I've always heard this. Every floor that the Empire State Building went up, at least one worker died.
Oh, wow.
That's what I've always been told. I haven't seen the statistics.
Now, there are 2 major factors in terms of considering a construction site case. One is the injury, of course, and the other one is the liability. 2 important words, I think, for our clients that are watching this to understand. Let's explain that.
Okay. I would actually turn those around. I would look at liability first.
Exactly.
Liability is a fancy legal term for fault. Who's at fault? If anyone. Sometimes nobody's at fault. Things happen. Okay. Damages or the injuries, that's the amount that it's worth. In order to get to the second phase, you need to prove your first one. You need to prove liability because a judge is not going to look to see how hurt you are in deciding liability. Whether you have a broken fingernail or, God forbid, you're dead, the liability is the same. So the first thing I look at is the fault, the liability. You know, when I get a client in, that's the first thing I ask them. And before I even start questioning them, because we are lawyers and we tend to cross-examine people, I just let them speak. I just sit there and I take notes. I said, just tell me your story. And I listen and I listen and I listen. Then I'll go back and focus on the different areas that I need to prove. For example, you fall off of a ladder at a construction site, that's a case. You fall off of a ladder, let's say at a supermarket while you're working, that's not a case. So the first thing I need to look at is this a covered person? Are they doing a material alteration? You also run into situations where people are doing repairs, routine maintenance. I'm sorry, not repairs, routine maintenance. That's not a case. If it's routine maintenance, the labor law does not apply. So I begin by focusing on the accident-producing activity at the moment. I freeze them there. Then we'll go into what happened. Let's assume it was a ladder fall or something. Okay, what kind of ladder was it? Was it an A-frame? Was it an extension? What was wrong with the ladder? Was anybody holding it? What kind of work were you doing? That's very, very important. You can give somebody a perfectly good ladder, all right, and it's still the wrong safety device. What do I mean? The guy has a drill and has to lean to the side a bit in order to drill, or back in the days when they had a screwdriver and you had to twist it and you're leaning to the side and the ladder kicks out and you fall. That's not the right safety device. He should have been given a Baker scaffold in that situation. So these are the types of things that I ask about early and often. Okay. Assuming that I'm satisfied with those answers, I get into the other things. Are there witnesses? Did you go to the hospital? When was the first complaint of pain? Have you had any prior accidents? One of the things that these defendants do is they'll try to say that maybe you were hurt, but you were hurt before. It's from degeneration. Mm-hmm. You would have needed surgery anyway, even if you didn't have this accident. Mm-hmm. Those are the kind of things you have to deal with head on. I'm an aggressive type attorney. I do not let anything sit. I deal with issues head on because I want to know my issues early and often. It's very easy to talk about your strong points of a case. A good lawyer can be identified by one who identifies his weak points and tries to fill in those weak points.
What about injuries?
Injuries, well, like I said, I talked to them about the ER, their first medical appointment. Sometimes I'll get a call from a client when they're in the hospital. Other times I won't get a call for a few weeks because the person was hoping to maybe shake it off and go back to work because they're not thinking about a lawsuit. So I'll speak to them about that. I'm not a doctor, obviously, but being that I've been doing this for 26 years, I've learned a lot of medicine. I'm able to give them, for example, if it's a back injury, I'll make them do the straight leg test. I'll make them walk on their heels if they can do it. I'll make them walk on their toes. Very, very simple exams because, again, I'm not a doctor. If it's a shoulder injury, give them I always forget, flexion, I think adduction. I know I'm butchering it. I get that. I did it with somebody yesterday. I had a guy from Local 3. He came in. His shoulder was in bad shape. And I said to him, can you do this? And this he was able to do. When we got to this, you could see his arm shaking. Mm-hmm. This, he didn't even try. Mm-hmm. Right? So now I know that there's a potential significant orthopedic injury there. I sit down with them. I go over their doctors with them. I don't suggest doctors. What I do is, not every doctor accepts workers' compensation. I make sure that the doctors they're going to are the type that do accept workers' compensation, do know how to put in for approval of injections, surgeries, things like that. But at the end of the day, the client has to be comfortable with his or her doctor. I'm not the one whose body is being opened up. It's theirs. So,
a client is injured, and what do you recommend they think about having had an injury, as, for example, in our discussion from a construction site accident? What are you wanting the client to think about, maybe in preparation of coming to see you?
In preparation of coming to see me, I tell them what the process is like. Unfortunately, some people out there, they think that the second you get hurt, you're automatically entitled to millions and millions of dollars. I disavow them of that notion immediately. Okay, I don't want people coming to me. I don't want to represent people that are just doing this for money. I want to represent people who are genuinely injured. I also talk to them about their medical condition and to write down for me for that first meeting the types of pain that they're experiencing and the frequency. Okay? I want them to be checked out thoroughly before they see me. Obviously, if you have the guy who's got broken bones and things, he's hurt. Mm-hmm. But let's assume it's what we call a soft tissue injury. All right? I want them checked out completely.
Soft tissue, just described. Soft tissue issue meaning?
As opposed to bone. A bone is hard. It's a fracture. It's orthopedic. Soft tissue, by the way, soft. There's nothing soft about it.
Yeah.
Okay. That's just the cartilage, the ligaments, and the tendons. All right. An X-ray would pick up bone. An MRI or a CAT scan would pick up the soft tissue. So I want them examined completely. Okay. A lawsuit is a long process, and if you're going to be in it for the long haul, I want to make sure that it's worth it for you and worth it for me.
A client is injured and is looking at the notion, I may bring a lawsuit on this because of the injury. Generally speaking, what would you say would be the percentage of construction site accidents to clients that wind up in a trial?
In trial?
Yeah.
Maybe 10% of all cases wind up in trial. And it's for multiple reasons. One, the law here in New York, it does benefit workers. And we can get a lot of times we can get what's called summary judgment, where we could win that first part that I mentioned a little while ago, liability fault. We could win that on paper. So the only issues we're going to trial on is the damages, how much. But also, once we get summary judgment, we have 9% a year combined. So if it's 2 years of interest, that's 18%. Mm-hmm. It lends itself to cases settling. Insurance companies don't want that interest ticking. Okay. The ones that do go to trial, it's either the really, really big ones or ones where there's just a dispute where they're claiming the accident didn't happen, they're claiming it was his fault, and you get those from time to time.
From the time that you hear a case for the first time, generally speaking, how long does it take you to make a determination this is a case for trial?
For trial?
Yes.
It varies because I have to wait till the medical treatment is done, till the injuries develop, see how many surgeries there are. Not every case is ripe for trial. Trials are expensive, and that money comes out of the client's end at the very end. So I'll just give you an example. I have a trial coming up in September, and one of my doctors needed me to book him from now. This trial starts, the jury selection, the day after Labor Day. In order for me to book him, I had to give him $15,000 today, FedEx, so he can get it tomorrow, to keep him in. That's just one doctor. That trial is going to cost me probably about $40,000, $50,000. And if you're looking at a recovery of, let's say, $300,000, that's not worth it. It's not worth it to the client because I get that money back at the very end of the case, sure, provided I recover. Mm-hmm. Just so everybody out there knows, if the client doesn't recover, none of us recover. We don't get our expenses back. We don't get a legal fee. We lose.
There are a couple of sections under you mentioned before, and section 200, 240, and 241.6. Can you give a little flavor as to what
Sure.
those areas are?
Sure. So 240, as I said before, is a statute, and it's a strict liability statute, which means if you find that the defendants were even this much responsible, they're in for the whole thing.
Mm-hmm.
There is no comparative negligence in those cases. Those are falls from heights, ladders, scaffolds, platforms, things like that, or objects that fall on people. When I say object, I'm not talking about, like a screwdriver or something. I'm talking about objects that are being hoisted. Let's say that there's a construction site going on, and you and I are on the first level, but the ceiling's open. They're working on the second level still. Something falls from there and hits us. That's a case. That's 240.
Mm-hmm.
Those are the kind of hazards the statute is meant to protect from.
Just on that, because I know how important 240 is, what percentage would you say of your cases are 240 cases?
My cases?
Yeah.
50%.
Are there that many?
Yes.
Huh? Okay.
Yes. Because you got to understand that the people who are getting injured in 240 accidents, they're hurt. They're falling from significant heights. They're getting hit by objects that are significant in weight. So those are the people that are seriously injured and proceeding with their cases. You get a 241-6 case, and I have some very heavy 241-6 cases. I'm not trying to say that 241-6 is somehow a child of a lesser God.
Mm-hmm.
Okay, but it's different. For example, if you trip and fall in a passageway because of debris that had been left there, that's a 241-6 case. Why? Because there's a code section that's been found specific by the Court of Appeals, so that therefore all four departments adopt it, that says that 23-1.7, I forget if it's A or B, mandates that you're going to keep passageways free and clear from debris and dirt. That's an example of a 241-6 case.
Mm-hmm.
A person tripping and falling as opposed to a person falling from heights. The injuries are different. And I tell my clients all the time, when I get their MRIs back or when I get doctor's reports back, I'm the one that will tell them, listen, as soon as your doctor says you need to go back to work, you should go back to work.
Mm-hmm.
You're not retiring over this case.
Mm-hmm.
I'll go back to work as soon as he tells you.
Mm-hmm.
The 240 cases, I don't have too many of those because the people are really, really injured. 200 is a fancy term. It's a codification of common law negligence. Okay? You can sue the owner and the general contractor for these vicarious liabilities type statutes, but with 200, you need to show some active negligence. Okay. They either knew or should have known about something that was going on there or a condition that caused it. I always throw in 200, but 200, it's not so easy to prove.
You mentioned a term that I think is extremely important, and I think clients would be interested: strict liability. Just define that a little bit.
There are very few statutes in the law that are what's called strict liability. And in this case, I said before, if you're able to find that the defendant was responsible, it's not a negligence standard. It's a vicarious liability standard. That's why I'm staying away from the word negligent. If you find that the defendant was even an iota at fault, the case law in this state, especially a case named Blake, says that comparative negligence cannot occupy the same plane as a statutory violation. And that's what I just said. If you find even a little bit, they're in for the whole shebang. It's very strict, and it's because of the inherent danger of construction work. It was done that way by the legislature. It was their legislative intent. It's been expanded by the courts. It's also been retracted by certain courts, but right now I think we have a pretty good court led by Judge Wilson.
Let's talk about something called statute of limitations.
Oh, yeah.
Very important.
Oof. I just cringed because every lawyer cringes when they hear the word statute of limitations. For the most part, you have 3 years to file a lawsuit. However, there are exceptions, and it's those exceptions that keep us up at night as lawyers. You have a city, you have a municipality.
I was going to say, let's talk about governmental defendants here.
And that's always the potential time bomb. And when I say potential time bomb, we lawyers worry about the statute of limitations because it could implicate us for liability, for malpractice, a word that none of us like to hear, much less use. When you have a municipality, you have 90 days in which to file a notice of claim. It's a simple legal document. It can be filed online now. You used to have to go down to the city and have it stamped, but since COVID, it's one of the few things that COVID did for us that was good. You can file it electronically. All you're doing is you're putting them on notice of the claim and giving them the opportunity to investigate it. They can conduct what's called a 50H. It's a mini deposition. They can ask you who you are, what happened, what your injuries are, things like that. And then you got to file the lawsuit within a year and 90 days. Now that sounds simple, and it is when it's, for example, a school. Okay, but then you have these entities, these municipal entities, these agencies that sometimes it's difficult to figure out that this is a municipal entity.
Mm-hmm. How many cases would you say have a tendency again to have a governmental entity as a defendant?
I think at this stage, with my union cases, I represent both union and non-union, but my majority is union. I think with my union, I'm seeing more and more because I think the bulk of the work that's going on in New York City is the school projects. There was some money that came in from the Biden program, from the Biden bill for the infrastructure. They started doing some bridge bills, but I don't know what's going on with that right now. But there's a lot of schools that are being built, and I'm getting a lot of cases. These SCA cases. SCA stands for School Construction Authority.
You mentioned notice of claim, and you mentioned a requirement of it being filed within 90 days. What happens if it isn't filed within the 90-day period?
You're out of luck. You can't pursue a case. Now, you can make a motion to file what's called a late notice of claim. Those are not easy. They're not granted easily by judges. And if they are, the appellate division is tough on them. Okay, assuming, let's leave that out of the picture. Unless you're in a coma, unless you're an infant, am I missing one? There got to be an extreme situation where the statute of limitations would be tolled. In other words, frozen. And with the construction workers, since we're talking about construction accidents, unless that person is in a coma, I don't see there being any kind of toll. So not filing within 90 days is likely fatal to your claim.
How often do you deal with that situation where the fella comes in and he's got a pretty serious injury and it happened 6 months ago?
It happens a couple of times a year. I do a couple of things. I make my motion immediately. I have my client sign something, though, when they come in, saying that he came in on such X date, which is 6 months after the notice of claim deadline, that I advised him that it was blown. I have to cover myself. Then I immediately make a motion. Maybe if he had a prior attorney, maybe let that attorney know that there's a potential problem here. Mm-hmm. And that's about it.
I just want to check. I know that obviously our discussion is construction site cases. What are some of the other area and types of cases that you both go to trial on and represent?
So I have my own practice where I work up cases and I have associates and things like that. But I also try cases for other people. Okay. Auto cases. I picked up a case today. It's a bus accident. It's going to go on trial, I think, in November in the Bronx. Heavy injuries. I'm trying it for somebody else. The attorney I'm trying for, excellent attorney, very good on paper. He's not a trial guy. Mm-hmm. You know, God gave me the gift of gab. Okay, mm-hmm. I'm miserable at my desk. I love talking, so I pick up cases for other people. I've done trip and falls. I do not handle medical malpractice cases.
Okay.
I tried one of those cases early on in my career. I wasn't thrilled with it, and just didn't want to do it again.
I think people are very interested in the word taxes. So you get a verdict, or you negotiate a settlement. What is the impact of taxation on the individual client?
The client does not pay tax on that money. Unfortunately, I have to. Mm-hmm. Okay, but the client doesn't. I have this young associate. He's a young Spanish fellow, and he tells the Spanish people, and I love it. I've adopted this term because I think it's fantastic. When he explains it to them, he says, "This is blood money. You don't pay tax on this." How does he say it? Because I understand a lot of Spanish, but I have problems saying it. Sangre. I can't remember. I'm not going to even try to make it up, but that's basically what it is. It's like blood money. You don't pay tax on your lawsuit money. If there's a verdict and the interest gets factored in, you do pay taxes on the interest.
When a client calls with a prospective set of facts for a case, how does your office handle that? Who speaks with them, and what information is essentially generated?
All right. So the first contact that's made would be a paralegal. Now, there are differences. For example, I get cases sent to me directly. Maybe somebody met me at a union event or something. I'll take those calls, but for the most part, it's going to start with a paralegal, and the reason is I need their demographics. Okay, a lot of my clients are Spanish speaking. All my paralegals speak Spanish,
Okay.
so they'll get the demographics in. After that, a lawyer must speak to them. That's the rule in my office. If I'm not on trial, just because I happen to be a people's person, I'll probably speak to them.
Okay.
I can do it quicker than most people can because I've been doing it for so long. But then when that person comes to the office, my office is not like others where they'll put a paralegal or something like that to sit with the client. There has to be a lawyer there because you could make or break your case in that first meeting. That memory that the client has of the accident will never be as good as at that first meeting. And I want all the facts down for another reason. When I prep a client for a deposition, the first thing I pull out is that intake, because my intake is about 12 pages.
Okay.
And if they forget, like for example, John, do you remember what kind of ladder you were on? I don't remember. Well, when you came here 2 days after the accident, you told me that it was an 8-foot A-frame made of wood. Do you remember now? Oh, yes, I do. Okay. Mm-hmm. So we are very careful with those intakes. This is not like, for example, again, there are some auto cases that are very, very serious, but it's not like you're looking at a police report. This one was coming this way. This one was coming that way. Oh, it's a question of lights. Construction cases, they're nuanced. You need facts, a little simple fact to make or break your case. And I want it from day one.
I introduced you as saying a highly prominent attorney. And anyone who has watched any portion of this will certainly agree with me. And I deeply, deeply thank you, Nick, for your great information.
Thank you for having me. It's been my pleasure.
Our pleasure, believe me. I just wanted to mention that each month we will have 2 podcasts. One will run from the 1st of the month to the 14th, and the second one will run from the 15th to the end of the month. And we hope that you will take the time to watch some of them, of course, in addition to today. Thanks very much for your time and interest.
Thank you.
Bye now.